So I hadn't planned on really talking too much because I'm moderating this panel, but it's impossible to start this panel without acknowledging how quickly states are moving, particularly this week, to erase reproductive rights, particularly Roe versus Wade. When I think about reproductive rights, I think of a broad array of issues: access to health care, access to insurance to cover birth control, for fertility treatment, for pregnancy care, for pregnancy termination, comprehensive sexual health education from puberty through menopause and beyond. Personally, I would love for somebody to help guide me through this perimenopause piece. Forced sterilization, taxes on feminine hygiene products, abortion care, disparate impact on women of color and poorer women and rural women. I want to acknowledge that for too many women in this country, and indeed around the world, reproductive rights are effectively non-existent. In the U.S. alone, thanks to the Hyde Amendments and years of increasingly draconian restrictions on access to abortion, the full promise of Roe, which I had always believed to be women's rights of sovereignty over our own bodies, has never actually been fully achieved. Which brings me back to where we are today. There is something fundamentally different if, as many of us anticipate, if we become a post-Roe country. When the law of the land denies a woman a right to choose what happens to her body, as a country, women are not free, and we are certainly not equal. The law, or at least the authoritarian majority on the Supreme Court, are devaluing women, our lives, our judgment, and enforced the millennium of subjugating women's power. So where does this leave us? We need to fight. We need to fight back hard. Not just for ourselves. I have a little girl. I know many of you do. This is not the world I want to leave to her. We need to fight for our sisters who don't have access throughout Mississippi, throughout Alabama, throughout so many parts of this country. We also need to be creative. We need to invest at home. We need to invest for things we can do more at home. Safe kits, safe access to home abortion medicines. Maybe we need to start an underground railroad. Maybe we have a floating clinic like our Irish sisters did for so many years off the coast of Ireland. Maybe we have a boat running up and down in Mississippi. Maybe we have it off the coast of Alabama. We need to convince our fellow Americans to love and trust women again. And I think about this a lot. You know, abortion is basically, we'll get into this, a line of cases about privacy, which is incredibly important. Maybe it's time to stop being private about abortion. Maybe we need a Me Too of abortion movement. Women acknowledge, so many of us have had this life experience that has liberated us from what would have been lives we would not have chosen for ourselves. Maybe it's time for those of us who have had abortions to be more public about it and not cloak it in privacy anymore. Maybe that would be part of our battle. I also think a lot about how quickly it feels, although I know it was many decades in marriage equality, and how quickly it felt like we went from zero to attaining it. And when I think about that, I think about what really happened there was love. It was all about love. All of us love somebody who's gay. All of us love somebody who loves somebody who's gay. And at the end of the day, justice and equality is better achieved with love. So maybe that's what we need to be thinking about when it comes to some of these abortion cases. Let's believe in ourselves. Let's believe in women's judgment. Let's believe in our future as powerful women. We need to fight like hell and know that justice, equality, and love will triumph again. We have the most amazing panel today. I will quickly introduce folks, and all of their bios and their many accomplishments are in your materials. Lena Anderson is class of 2012 here from Northeastern Law School. She is currently the Associate Director of Public Policy and Government Affairs for Planned Parenthood in Massachusetts. And her recent success includes a contraceptive access law passed in November 2017 to protect and expand access to no copay birth control. and repealing an unconstitutional criminalization ban on abortion care. Lita also, I asked folks to give me a fun fact that you won't get in the biomaterials, and I love Lita's. She's certified scuba diver and has dived all over the world and swam with sharks. What else could be more apt? You need people who can swim with sharks. Sitting to Lita's right is Jamie Savino. Jamie graduated from Wellesley and also is class of Northeastern Law School since 1978. She's a staff attorney for the Mass Law Reform Institute and co-manager for Civil Legal Services for Victims of Crime Initiative. When I think of reproductive rights in Massachusetts, nobody comes more to mind than Jamie. She's been fighting this fight for decades. I actually was lucky enough to be trained by Jamie over 25 years ago to do Mary Moe hearings here in Massachusetts, which is advocating for minors seeking court permission for abortion. And I love also Jamie's fun fact. In 1974, when she was a congressional intern, she ended up on the front page of the New York Times as being one of the first 3 people in line to hear the Watergate tapes hearing at the Supreme Court. She waited in line for over 44 hours. So if they do release finally the unredacted Mueller report, I know who I'm competing with here. Our next guest is Dr. Nina Kozba. Nina is an obstetrician gynecologist, family planning specialist at Bay State Medical Center, and assistant professor at the University of Massachusetts Medical School, Bay State. She completed specialty training in family planning at Yale, where she also received a master's degree in public health with a focus in healthcare policy. She provides abortion care at Bay State Medical Care and Planned Parenthood of Massachusetts. And she hopes much of her work is focused on improving delivery of reproductive health and abortion services through implementation and policy impact research and legislative advocacy. Nina also is part of an organization that I'm very proud to do some legal work for, Physicians for Reproductive Health and Choice. They're all over the country. They're going into places that have no care for abortion services, sometimes at their putting their own lives at risk. It's an incredible organization. And Nina's fun fact, she's a Boston native, and when she was growing up in middle school, she was part of a competitive juggling team. And she wound up performing at the Celtics halftime show. You'll hear Celtics theme soon. Deborah Waltz, who I can't thank enough for flying across the country to be with us. Deborah's class of 87, and focuses her practice on family formation, including egg and sperm donation, surrogacy and adoption, and parentage and custody litigation. She is a fellow of the Academy of Adoption and Assisted Reproductive Attorneys. And one fun fact about Deborah, her younger son is one of the 2 most famous superfans of the Golden State Warriors. Her son is known in San Francisco as the Gold Suit Man. Google this, it's awesome. Which resulted in Deborah having a cameo appearance in a Warriors promo video and accompanying her son on the red carpet in Vegas for the NBA Players Award. Having grown up in Boston during the Larry Bird era, she claims to have a soft spot for the Celtics, but I think she's Warriors through and through. So, I'd like to start by turning it over to the panel, and if you could briefly tell us what inspires you to do this work, and what inspires you to keep doing it. I think people would appreciate hearing that from each of you. So, Deborah?
So, it's actually really nice to be here. I'm from Cambridge originally, and I don't get to come back very much. So I was a public defender. And I started having babies, and it was the early 90s, and there were very few protections in place for same-sex couples having children at that point. And so my journey to here really started with trying to figure out how to protect my own family and my own children. It was the mama bear in me that led me to where I am right now. And when I started doing that work, so I was actually, my mother was a very well-known women's health advocate. She consulted with the original Our Bodies Ourselves, Foster Women's Health Book Collective. And so when I started doing, advocacy for lesbian and gay couples having children. Through my own, just figuring out my own path forward, and then word of mouth, and then it's sort of there. Actually, when I started doing advocacy for LGBT parents, my position was very clear, which was, as far as surrogacy went, that if it worked, great, but that I would never take a position advocating for a woman to not be able to raise a baby. She was very clear in that position. And then I started having more gay male clients. And actually, when I was telling some folks at dinner last night, one of the first cases that came to me, I was called in my office on behalf of a gay man who was having a child, or wanted to have a child using donated sperm, donated eggs, and a gestational surrogate. And I got so judgmental. I'm thinking, what is this guy, some entitlement queen who's decided he has to have a baby that's being, sort of custom made for him, and there are all these children out there that need loving homes, and why isn't he adopting? Well, then I met him, and he had been diagnosed with HIV in the 80s when he was in his 20s, and he'd assumed he was dying. And he had spent from his 20s to his 40s waiting to die, while building a life for himself. But he always assumed he was going to die. He had always wanted to be a father, and he'd given up that dream. And in his early 40s, his community said to him, "You're still here. You're not dying. You would be an awesome father." And a group of people came together around him. One of his dear friends offered to donate her eggs. One of his dear friends offered to donate his sperm. And someone came forward willing to carry for him. Boy, was I not judgmental. So basically the invitation was to be part of his community. So it was through personal experience that I ended up evolving to a place where probably half my practice is surrogacy law at this point. And honestly, my position around surrogacy largely evolved from starting to represent surrogates, who I have experienced as actually a very empowered group of women who have figured out that in this society, and we can have a much bigger conversation about the society we'd like to live in.
And we will.
And we will.
Let's go to this.
But in this society, this is a gift they can give others. And anyway, so that's sort of how I got here.
Hi, everyone. Thank you so much for having me here. It's truly an honor and a privilege. I think what was really informative for me and inspired me to get into this work was actually one of my co-ops I did during law school at the ACLU's Reproductive Freedom Project in New York. So the co-op program is incredible. I always considered myself a supporter of safe and legal abortion. But that experience truly opened my eyes up to the attacks and assaults on reproductive freedom that I think a lot of people in my generation have been taking for granted. And I think, what we were seeing over 8 years ago feels like it sort of pales in comparison to what we're seeing today, which I know we're going to talk about. And that really inspired me to get into this work. What continues to inspire me are the people that I work with day in and day out in this movement who are so dedicated and so incredible. But also, first and foremost, I think the patients that we serve at Planned Parenthood, who come from all walks of life, who deserve compassionate, non-judgmental health care, because despite what one lawmaker told me on Beacon Hill, abortion is health care.
So Roe v. Wade came down when I was, and I didn't even know this. We were fighting a war. We had more things, but And I had a fairly backward group of friends who weren't even dating, so these issues weren't on the radar. I assume we read Roe v. Wade in college, Ellen Berman, but I don't really remember. Abortion was sort of never an issue on my radar screen at all until March 1981, where there was a notice in the Women's Bar Association newsletter that there was this law going into effect the next month about minors having to go to court for authorization of abortion. And they were doing a training and they needed lawyers. So I was working on criminal justice issues, death penalty issues. I kind of didn't even know there was a reproductive rights movement. But lawyers, access to justice, okay, that was in my wheelhouse. I came, went to this training, joined the organizing steering committee there because I'm really an organizer, and started doing this. And by the time I represented maybe 2 or 3 young women in court, it was like, wow, this is the most important decision women have to make. This is a basic civil rights issue for women. And it became my sort of cause. Reproductive rights generally, and particularly access. And let me tell you, if you find a really tiny area of the law and get in at the very beginning, you too can be a national expert.
So my story, actually, I wanted to be a lawyer. This was the closest I had come to. I do feel like a lawyer. Fortunately, a lot of the time in my exam when I was out, I have to advocate for women's access to abortion care. I could tell you numerous stories of the brave women I've cared for. 3 years now since coming out of fellowship. One story in particular I wanted to share that I wasn't personally involved with, but I hope that you guys have heard her story because I think it can make an impact here in the U.S. How many of you have heard of Salva and her case in Ireland? So I can't pronounce her last name very easily, although I'm Indian, but her last name is Indian. So just briefly, she was an Indian woman who went to Ireland on vacation with her husband, who was approximately 20 weeks pregnant, and her water broke. And at that point, that's called, in medical terms, an inevitable abortion, meaning their pregnancy is inevitable. And because under Irish law, abortion was not legal, she died of multiple organ failure. She died a horrible death. And when I saw Salva's face, I saw my face, and I said, this cannot happen. And this week, more than ever, I feel like it's closer to happening here. And that's what inspires me to keep going and keep fighting.
Would you pass it to I do want to turn us to an overview of the current state of reproductive laws in the country, and I'd asked Jamie to sort of give us a perspective, maybe thinking about the last few administrations and how the law has evolved over the last few administrations and what attitudes have arisen in each of those different circumstances. And then we could talk to Lita about maybe what's going on in Massachusetts next.
Great, thank you. I just want to say that I was involved in the study of Planned Parenthood and had my name on the article, which was published in the Journal of Obstetrics and Gynecology. So that's as close as I'm ever going to get to it. So looking at the last 4 presidents, last 26 years, I'm going to touch just very briefly, because when I teach this, it's like an hour class. Very briefly on changes that deal with the legislature, with who's the president, and the court. The legislature has had a very odd, at the federal level, reaction to abortion legislation. All the anti-choice people consistently say this is a states' rights issue. But for the very first time in the early 2000s, the federal legislature, Congress, passed law on abortion. There's been a movement among many state legislatures to pass what people, the so-called partial birth abortion, restrictions on certain types of abortions, generally later in the trimester, and they've been ruled unconstitutional. The federal House and Senate passed a law embodying this exact same thing, So it was the first time the legislature at the federal level felt emboldened to actually legislate. Earlier in the 1990s, Congress had tried to pass, and the House passed a couple of times, a bill making it illegal to go from your state to another state to avoid parental consent laws. That never passed the Senate. In the early 2000s, the House and Senate and George W. Bush signed into law legislation around abortion. It hasn't happened since, but I always put that on people's radar, that it's not just the courts and not just the president we have to worry about. We have to worry about who's in Congress. Who's president does make a huge difference, besides the court appointments, which live on long after their reign. Who's president makes a huge difference on federal regulations around health care, and what we all have been hearing about recently is Title 10, the domestic gag rule. This happened before. George H.W. Bush, in his reign, they passed the domestic gag rule. It was upheld by the courts through the Supreme Court and was only overturned by Bill Clinton. First day of presidency, he overturned that. And it was interesting because everybody assumed that George W. Bush would reinstate it, but he didn't. It was left to our current president to do that. Regulations around Title 10 are really important. And I kind of always knew that they have demonstrating about abortion, but for God's sakes, it's 2019 and birth control is still an issue, so that bothers me. But the most serious issue is who's on the Supreme Court at the moment. And a couple of things have happened in the last couple of weeks I think give people great pause. A little historically, in 1992, the Casey decision came out, and while people always say Roe v. Wade is the law of the land, it isn't, because Casey changed Roe. It kept in the right to abortion, right to privacy, but it changed the standards by which state laws and regulations can be measured. It made it no longer a fundamental right and strict scrutiny. So that was troublesome, and many, many regulations have been upheld since then, but not all of them. And they mentioned the partial birth abortion. State laws were struck down, but then the federal law was upheld. A couple of years ago, we had a remarkably wonderful decision in Whole Women's Health, a Texas clinic, which overturned regulations in Texas that would have forced the closure of many clinics. They're called targeted regulations on abortion providers, trap laws. But a change of one seat on the Supreme Court has changed that. But it changed it even more dramatically than I would have thought. For many years, the standard procedure of people opposed to a woman's right to have terminated pregnancy had been, let's chip away. Let's put this targeted law in. Let's do this. Let's do that. These legislatures are now emboldened because we have a Supreme Court that has clearly indicated this week that it doesn't care about stare decisis. In 1992, many of us thought Roe was going to be overturned. Yet 3 justices, moderate to conservative justices, said in the Casey decision, stare decisis is important. And a whole generation of women has grown up knowing they had this right. And people have organized their lives based on this. And in fact, the right to control your reproduction gives you the ability to be an equal citizen, economically, civically, to participate. Stare decisis. Even Sandra Day O'Connor, who 3 years before in a case had said, I think Roe's about to collapse, and she later apologized for saying that. This Supreme Court, despite what people have said, we all heard, both Gorsuch and Kavanaugh talk about the respect for stare decisis, and Susan Collins in Maine said, oh, that's why I voted for him. Earlier this week, on Monday, the Supreme Court issued a ruling overturning a case from 1979. Totally different issue about whether sovereign immunity applies when you're suing somebody in another state. And Clarence Thomas wrote a decision which said basically, well, we think that was poorly reasoned and poorly written, and yeah, there's stare decisis, but it's not so important when it comes to constitutional issues We think it was wrongly decided, and we're going to overturn it. The dissent by Breyer says, well, if they overturn this, what are they going to overturn next? So I am no longer as worried about the chipping away, though I certainly am clearly worried about that. I'm worried about much more.
Rita, do you want to give us a sense of what's going on a state level?
Okay. Given all the things Jamie just discussed and talked about, several months ago, before the legislative session began in January, really a while back, we started taking a deeper look at our laws in Massachusetts to understand what does access look like here today in Massachusetts. We have a reputation of being incredibly progressive, and this is Massachusetts. Of course our laws are good here, but that's not really necessarily the case. We do have an SJC decision from the early 1980s declaring abortion a fundamental right under our state constitution, and we were successful in the last legislative session in overturning a law from the 1800s criminalizing abortion. But regardless of those, so those things tell us that abortion will remain safe and legal in Massachusetts if there are changes to the federal level. But as we know too well, legality does not always translate into access. So we did a real deep dive looking at what are the laws on our books that are still erecting barriers to care here today. And I think it's important to have this historical context because what we found was that most of the laws that we have on our books today are a remnant of a comprehensive piece of legislation that was passed in 1974. It was intended to be a rebuke to Roe. The title of the bill then was called An Act to Protect Unborn Children Within Present Constitutional Limits. And it spelled out in its legislative preamble that it intended to do that. It was not intended to be characterized or understood as protecting or allowing abortion at any stage of development, but rather to protect the life of the unborn child wherever possible. We have definitions on our books relative to abortion and pregnancy and unborn child that are tantamount to establishing fetal personhood, which is a notion that was rejected in Roe v. Wade. We have a 24-hour waiting period on our books that a lot of people aren't aware of, intended to shame women and delay access to care. Thankfully, at the moment, that's not enforced. There's an injunction prohibiting its enforcement. But right now, the laws we have on our books are medically unnecessary. They create barriers to care. They tie the hands of doctors and interfere with the patient-provider relationship. And they fundamentally do not trust women, and they stigmatize reproductive health care both for the people who seek it and the people who provide it.
So, Nina, I was hoping, thanks. So, Nina, you've provided abortion care in 3 different states, Indiana, Connecticut, and now Massachusetts. And I'm wondering if you could share with us how restrictive laws in those states affect patient care and affect, sort of how you have to do your job as a doctor.
So I had the unfortunate opportunity, I guess, to see how zip code can affect your access to care. I had, you could call it the privilege. Got to serve women in Indiana. However, I was there for Governor Pence's reign, and he made it his #1 priority to start chipping away at women's access. That was my 2nd year of residency. And just a brief patient story. So I had a refugee woman from Eastern Africa. Indianapolis, for some reason, is a very large resettlement site for a lot of refugee groups, and so we saw a lot of refugees. This particular woman ended up in our GYN emergency room. Longer story behind it, but she presented for an abortion, and she asked me, she's like, I'm in Swahili for an interpreter. She said, I'm here for my abortion. I said, I'm sorry, you can't get it today. And she said, why not? I said, well, there's an 18-hour waiting period. You have to sign a consent, and we can't do it today. She said, aren't I in the United States of America? I said, yes, but you're in Indiana. And she said, what is this law? I thought I'm coming to a country that has access. This is, just, it was unbelievable to her. And so one of the many laws we had in Indiana was an 18-hour waiting period. By 18, not 12, not 24, 30, who knows? But 18 hours, a woman had to come, see a healthcare provider to sign this consent. Moreover, this consent contained inaccurate medical information. I'm somewhat glad that the newer version of this has removed some of the lies I had to tell my patients, but one of the lies I had to tell my patients was that abortion caused breast cancer. Although there's no medical evidence that shows that. How I know that as a doctor, I preface it by saying that the state of Indiana mandates that I read you this form. You can feel free to listen to me or not. So I read the form as legally required and as ethically required. I told my patient what was true and what was not true, and that was most of the form. That's only
when these states where you have to have these waiting periods, what I've come to learn is you actually have to sometimes meet with the actual care provider. Mm-hmm. So you can't have an administrative assistant or a nurse or a PA be the one who gives the consent forms and starts the clock. It has to be the doctor performing. So however much that wait period is, that doctor has to be back to see that same patient. Was that the case in Indiana?
So there was, the Planned Parenthood at least was we didn't have that, it had to be the exact same doctor.
Okay.
So at Planned Parenthood in Indianapolis, we actually had a video recording of our main abortion provider, and so we physically didn't have to be on site. That was workaround that our legal team. So it was a video of him reciting this mandate. But yes, there are states that have specified that have an actual provider doing the procedure that has to counsel them.
In some states, the doctor's only there once a week, so it's really a 7-day waiting period.
Right.
And so a lot of my colleagues who go to other states to perform abortion care, have to take capture the patient's thing. The waiting period was only a tip of the iceberg. Just to give you a list of other laws, we had a fetal burial requirement, so a woman that was presenting miscarriage or even an ectopic pregnancy, which is a pregnancy in the tube that can be life-threatening. They had to sign a form declining that they wanted to privately bury their fetal remains. Again, this was not medically necessary as another mechanism to shame women and to stigmatize abortion care. And I specifically remember the nurse coming after me and was like, "Oh, you have to sign this form." I said, "She has an ectopic pregnancy." So I was like, "We're not signing the form right now. I'm bringing her to the operating room. Someone use the form, deal with it later." So in Indiana, as you can hear, there was lines, just all these forms, all of these requirements that we sadly had to follow. I had sort of like a PTSD, if you will. Our attendings in Indiana were very cautious of residents, so in training to sign these forms, because there was a threat. And Pence made that very clear. He put pro-life people on the state medical board, former executives on the state medical board. And so our attendings, as a way to protect us, didn't want to sign a lot of these things, just to make sure that our rest of our professional careers wouldn't be on the line for something so silly as paperwork. And so when I came to Connecticut, I was sort of highly on guard, like, what form do I have to fill out, where do I sign? I remember my fellowship director's like, "It's okay, it's not Indiana." I'm like, all right, it's going to take a lot of getting used to, because there was a lot of forms I had to sign. Do you want me to talk about Connecticut and Massachusetts?
If you want to touch a little bit on it.
And so obviously Connecticut didn't have a lot of these restrictions. We didn't have a waiting period. Connecticut did have access for abortion care fee through Medicaid based on state statute. So there was access, something like that in Indiana. We did not have minor parental consent laws in Connecticut. The difference between Connecticut and Massachusetts are twofold. One of them is parental consent, so we're going to talk about that next. So Connecticut does not, Massachusetts does. And the other difference is how we define gestational age. And so in Connecticut, it was by gestational weeks, meaning there was a hard cutoff at 23 weeks and 6 days. Massachusetts, in return, defines it as menstrual weeks, so it gives us leeway, usually by 2 weeks. So technically speaking, you could get an abortion a little bit later in gestation in Massachusetts. However, just like as Leah mentioned, legality doesn't mean access. A lot of allowing that just because of the vagueness of the law, and also what that could mean socially and politically. So in essence, there's still that same gestational age cutoff here.
And that's a real issue in Massachusetts. I shared with some of the panelists just a couple of years ago. I had a good friend who was very joyfully expecting her third child and got to her 18-week ultrasound and had nothing but horrible news, and but needed some time to really confirm the results of the ultrasound and figure out what she was going to do. And it was unbelievable because she had all the resources in the world. She's a school teacher, middle class, has great doctors around her. She has a best friend's a lawyer, and what we had to go through to get her access to care was extraordinary, because you can't get appointments for the next ultrasound, or you can't get appointments for the next test to confirm what's really going on. And the clock's ticking, and the clock's ticking, and the hospitals will try to be a little flexible, but not so flexible. We had looked into going to New York. In New York, it would have bought us an extra week of decision making. And ultimately, what she had decided to do, it was very important to her to honor the experience of the pregnancy, was to be induced and to give birth the same way she had delivered her other children. And I was terrified that there would be a live birth in the hospital, and what would that mean? And so we wound up talking to the hospital ahead of time, and they were actually extraordinary care providers, and they had a special part of the maternity ward where they would allow her to birth, and if the baby had survived, allow her to be with the baby for a little bit, as long as she wanted, and that's in fact what happened. But at one of the worst and most horrible decision-making points in her life, we had to worry about what the state was going to tell her she could and could not do. It's just extraordinary. So that's Massachusetts. Imagine outside of the country. So these rules about how we calculate, gestational age, last menstrual cycle, is critically important at times in women's lives. It really plays out in very unfortunate ways. So thank you. So I want to pivot to Deborah, because your practice really focuses on how families are formed. And can you give us a sense of how the legal definition of what a parent is, how that has evolved in your practice?
Yes, it's evolved completely, honestly. And interestingly, New York and California, which people think of as very progressive states, were really late to the party on broadening their definition of what constitutes a parent. And New York is still quite problematic. And I think that's because the question got called in some of the more progressive states much earlier in history. There are actually states that never really grappled with the question of what's a parent until much later, came up with much more sort of modern definitions than some of the states grappling with it early. So again, I came to this through advocacy for LGBT families, and it was critically important for our families to move the definition of what's a parent away from biology. So, I spend hours teaching this when I'm teaching it, but in, 2 minutes. There was a huge period of history before we had an effective, efficient way to know who a biological parent was. So a mother was the woman who gave birth, and if there was a father, it was her husband. If she wasn't married, there wasn't one. And then we got all this DNA stuff going on, and we're still grappling with what do we mean when we say father, or who is a second parent? Are we talking about biology, or are we talking about experience? California has, over the years, really evolved to a very child-centered approach, and it was largely through advocacy by the LGBT community to have our families be validated by the courts. And I always still today, and especially since we seem to be moving backwards at an amazing pace, need to point out to people that marriage equality is not family equality and it's not parentage equality. And the fight to have same-sex couples recognized as parents of their children was not won with Obergefell at all. And we're seeing vicious attacks again on that. But we're trying to move the country to a place, first of all, where the marital presumption is applied gender neutrally, which is being a huge battle. And second of all, where children's experience of who their parents are is validated by the courts. And that's probably the most critical piece of it. And again, it's come a lot, not entirely, but a lot through the fights of lesbian and gay parents to be recognized as parents to the children they've raised when something happens.
So let's switch gears a little and talk about minors and younger women. Jeannie, you've probably done more than anyone in Massachusetts to expand reproductive rights care and abortion access to minors. Can you tell us about your experience doing this work and what do minors need to do to access this level of care?
So, we're talking about Massachusetts as the wonderful progressive state. Well, as Lita said, in 1974, it wasn't our highly opposed to the Roe Act. We had a doctor prosecuted for performing an abortion here, and they tried to put as many barriers as possible. And the Supreme Court, even at a period of time when it was striking down waiting periods and various other things, upheld restrictions that affect the most vulnerable people. The Supreme Court upheld parental consent provisions, and it upheld provisions that barred Medicaid funding for abortion. State level, that's changed in certain places, but not very many. And parental consent, judicial bypass is now in 37 states. Massachusetts was the first. We have the longest consistently enforced parental consent judicial bypass. So if you're a teen in Massachusetts and you wish to have an abortion, you must have either the consent of one of your parents, the original law was 2 parents, we did get it struck to 1 parent, or an authorization from a superior court judge. The minor has a right to go to court to show that she's mature enough to make the decision on her own, so the judge is merely authorizing a physician to perform the abortion based on the consent. Or if she's not mature, that the abortion's in her best interest. Well, Massachusetts is one of the strictest laws. In implementation, I can't say it works, but it's navigable. Virtually every teen gets her abortion request approved in Massachusetts. 98% of them are found mature, so they're making the decision on their own. And as one judge said, yeah, she walks in my room. I can find her mature that moment. She's acknowledged she's pregnant. She's gotten counseling. She's talked to a lawyer. She's figured out how to get out of school. She's figured out how to get to court. And she's willing to tell some black-robed stranger when her last period was. I don't have to ask her many questions. Interestingly enough, and this judge asked me 4 questions, they all be approved. He was one of the meanest, stupidest judges we had in Massachusetts. Nobody wanted to be fun with him. But as a human being, he recognized what was going on. This is not true in other states. You know, in Indiana, they're mostly denied. In Louisiana, they're mostly denied. In Texas, Austin, you're okay. Houston, I don't think minors are any more or less mature in other states. It's all about the judges. So basically, you have judges making these decisions. Now, as I say, they get approved in Massachusetts, but that doesn't really take into account what these young women. There's delay, and there was the recent study done by through Planned Parenthood, which documented the delay, which sometimes takes certain medical choices away. Delay also increases cost. It increases potential lack of access and increases confidentiality loss. The longer you're pregnant and growing up, the more your mother's going to figure out something's going on. Or to get to court, you have to tell a friend to get a ride, and that friend tells their mother, tells your mother. To get out of school, you have to tell somebody so your parents aren't called. And usually that works out all right, but not always. And for minors who fear adverse consequences from their parents' learning, which might be harm to the family. You have kids who are saying, yeah, my mother has a brain tumor. My brother just committed suicide. Normally I tell my parents, but I can't now. or those minors who have such a perfect relationship, never done anything wrong in their lives, say, I can't tell my parents I made a mistake. When you raise your kids, make sure you tell them they can make mistakes. You know, model it. Tell them about your mistakes. It's easy in my family. And there's shame. Who goes to court? Criminals go to court. You're walking, even though nobody knows your name, you're walking in there, and this is Superior Court. No other teenagers are in court, so everybody in that office knows why you're there. Sometimes people run into people they know at the courts. And the anxiety. Even if I can tell them 1,000,000 times, pretty much every petition is allowed. One minor walking looked at me and said, but what if the judge doesn't like my face? What if it's me? The most important decision of their life is being made by this little black robed stranger. So there's a level of trauma. The kids consistently say the abortion's a breeze compared to going to court. So it's a serious restriction. I was at some Roe rally once, and some older doctor got up and said, we won't go back to the old days before Roe, where you had to go per authority figure to approve your abortion. You might have to travel, you might have to go out of state. Well, in Massachusetts, that's what minors do. Most kids tell their parents. That's true in states that have these laws and don't have these laws. So the Roe Act that Lita was talking about addresses two of the greatest barriers. One is the being able to have an abortion for fatal fetal non in the third trimester, and the other is parental consent. Right now, kids are hitchhiking to court, they're going out of state, they are taking measures that perhaps aren't safe and delaying the health care that they need. And that's what I want every one of you to do is go to the Planned Parenthood website, sign up for the alerts, because the only way this kind of law will get overturned is if every one of you calls your representatives consistently. They're hearing from the other side. They know that this is, the right thing to do, but are they going to push it with the Speaker of the House who doesn't like to have people vote on controversial things? This is going to take a legislature by legislature convincing that these are bad laws and they need to be changed. And if you're a parent, what you want to say to them is, I'm a parent. And I always say, I'm a really nosy parent. I know everything happening to my kids. I go on the Wiser to check their grades. I'm the stealth parent. I'm not a helicopter. I don't touch anybody. When I'm on their It's a nice thing. I still, if for whatever reason, my kids felt they couldn't come to me with something, I want them to get safe health care immediately without trauma.
So Nina, from a provider's perspective, how does the legal requirement for minor consent affect how you treat your patients?
So when I first came to Massachusetts and had a minor, I was going around my business, getting her consented, and they said, Massachusetts has parental consent. I didn't even realize that. That was Massachusetts, not Indiana. So it came as a shock to me that was one of the requirements here. I think it's best illustrated by a couple of patient stories. So the first, and these are all within the last, couple of months, so they're all very recent. And these were stories I shared with legislators on Monday, when we were talking to them about needing their support for the Roe Act. So the first story, I'll call her Sarah. Sarah is 16 years old. She first made contact with Planned Parenthood, saying that she was pregnant and the clock was ticking because she was later in pregnancy, and it's actually very common that adolescents present for care later in pregnancy because of delayed diagnosis, fear, stigma. So the clock was ticking, and Planned Parenthood knew that, so she quote unquote aged out of Planned Parenthood, meaning she was beyond the gestational age limit for Planned Parenthood, needed to be seen in hospital-based care. So that's how we got involved at Bay-State. And there was surprise on the patient's part that she needed either her care or she needed to go to the judge. So she was a brave and courageous girl and had that conversation with her mom. And her mom reluctantly came to the visit, although 3 hours late, and so we had to rearrange the whole day, and, luckily we had the flexibility in our office to do that. But Sarah was one of the lucky ones. She was able to have that conversation with her mom. Mom had to take 2 days off from work, Sarah had to take 2 days off from school. And what boggled my mind, because not only there's a surgical consent involved, there's the consent for the abortion from the state of Massachusetts, and then there's an anesthesia consent. And so it was sort of very telling to say, all right, Sarah, you can sign this one for your IUD, you can't sign the one for your abortion, but you can sign the one for your anesthesia, but your mom has to sign this one also for your abortion. So it was very, I thought, just the sort of physical nature of having, showing them where they could and could not sign. And so Sarah in the state of Massachusetts can sign for her IUD. You do not need parental consent for contraception care. Because she's a pregnant minor, she is allowed to consent for other medical care, including her anesthesia for her abortion, so she can sign that consent for herself, but she cannot sign for consent for her abortion. And so trying to explain this in the patient room to the mother, and her mom went to me, she's like, why is this like this? And I said, truthfully, I'm like, because the legislator made these laws. And she's like, well, how do we change this? I said, you have to vote. That's one patient story. Another patient story, unfortunately, is incredibly more tragic. So she is a younger minor who is likely a victim of sexual assault, although it's still under investigation. But she presented to her pediatrician for constipation. And a very astute pediatrician noticed the size of her abdomen and got an ultrasound and a pregnancy test. And this 14-year-old was found to be pregnant later in gestation over the legal limit in the state of Massachusetts. And so as a likely rape victim, her only choice would be to go out of state. And so with Planned Parenthood's help and our coordination, we were able to set that up for her. As you can imagine, that takes a lot of resources. Parents need to get out of work, drive her there, get her there. In the end, she continued her pregnancy and the ultrasounds that we were discussing because everything happened so rapidly just to get her into care. Her first ultrasound didn't include what we call anatomy or looking at every single organ in fashion. And so, 3 or 4 days later after she initially presented, we got her in for that more detailed ultrasound, and it showed a potential brain anomaly. And so, she was first stuck being pregnant, and now she's stuck being pregnant with a fetus that may not survive. And so, unfortunately, there's no tragic stories of how legislators don't need to legislate medicine and how these restrictions are just limiting care. I think Leo will do the overview of what we're hoping to do with the ROE Act so women like these can get access to care here in Massachusetts.
So as has been alluded to a couple of times now, we have a piece of legislation that has been filed this session, and it's called the ROE Act. It is a comprehensive piece of legislation that will do many things. It will codify the right to safe and legal abortion into our state law. It will modernize and update those sort of inflammatory definitions and language that we have on our books. So rooting how we define abortion and pregnancy in medicine and science instead of ideology. It will remove the 24-hour waiting period that we have on our books. And I think most importantly, it creates an exception for care after 24 weeks. So as we talked about, right now in Massachusetts, the law prohibits abortions after 24 weeks unless it's necessary to save the life or health of the pregnant person. And what that does not account for are cases that are rare, but when there is a lethal or fatal fetal anomaly. And right now, there are some places on the East Coast that you can go, extending a couple weeks out. But really, there's only two places in the country that you can go to access this care. There's a clinic in Colorado and a clinic in New Mexico. It costs tens of thousands of dollars to travel, access this care. It's not covered by insurance. And that really limits care to a certain class of people who have the resources and who can afford it, which is unacceptable. We're sitting here in Massachusetts with some of the best hospitals and medical institutions in the country, and people should really be able to access the type of care here. And the other, one other important thing that this legislation does is repeal our parental consent law. We've talked a lot about that, but I really just want to underscore something Nina talked about earlier in terms of how our law treats young people and treats access to health care and how it stigmatizes abortion, because the law recognizes the necessity of young people being able to access timely care when it comes to contraceptive counseling, when it comes to STI screening and treatment, when it comes to mental health services, substance use services. And a pregnant person, a minor, is considered an emancipated minor and can consent to all medical procedures, not only related to that pregnancy, but writ large, except whether or not to end that pregnancy. And that's just not acceptable. And we know when we erect barriers to care, when we force young people to go through the courts in order to access this care, they're going to do what's easier. I was just talking to our patient navigator earlier this week who told me a story about two young people just last week who could not go to their parents for whatever reason. They had insurance. They could have gotten care here in Massachusetts and that would have been covered. But learning about and understanding what the judicial bypass process would entail, they opted to go out of state because our neighboring states, not only Connecticut, but New York and Vermont, don't have an age of consent for care. And so they chose to go out of state instead of getting their care here in Massachusetts, which we know. Oh, we're going to wrap it up.
No, that's okay.
Neil's giving me the So I apologize. We had so much more to talk about and so much more to cover that we didn't get to. Folks will be around during the break, so please feel free to talk to any of our experts. And thank you all so very much for considering so much.
We're actually not going to take a break. We're not, sorry. If you absolutely need to go, please do, but we're going to move right into our next panel to try to catch up a little bit of time. So Mala, thank you all very much. So timely and informative. Mala, come on up. Amy Carlin, Deborah Katz, Beth Myers, and Hannah. Establish the right to keep your